Hey everyone, Harry here to talk about the historic indictment of former President Donald Trump on a 7-count indictment out of the Southern District of Florida. You know, on the one hand, we've known it was coming. I today predicted it would be within 1 to 3 days. It was more like 1 to 3 hours. The table was completely set once Trump received that target letter. It was a foregone conclusion, basically. I can think of 1 or 2 instances where the department sent a target letter and not gone ahead with charges. And that's where the defendant took the opportunity to go to the grand jury and try to explain his way out. It wasn't going to happen here. Or a defense team gave the Department of Justice something to really pause on, though typically when that happens, there are still charges at the end of the day. But that wasn't going to happen here. They had their big meeting Monday and gave them essentially nothing to chew on. So we knew it was coming, and very soon. But, you know, it is a breathtaking moment. Take a step back. We've been thinking about it for years. It's by far the biggest prosecution ever taken by the Department of Justice. It's a true Rubicon crossing moment, and it puts us in the company of other advanced nations who are, at least this is the unavoidable first step to trying to handle corruption and lawbreaking by the highest officials in the country. And it couldn't be more momentous. And even though predictable, it's still, you know, makes you gasp with the significance of it. It's clearly one for the history books. All right. 7-count indictment. We're learning a fair bit about it, but more is going to be coming out in the next few days. Trump has been ordered to surrender on it in the Southern District of Florida in Miami, but the charges are, at least include 1519, 18 U.S.C. 1519, which is basically obstruction. And the general thrust of this being in the Southern District of Florida is to emphasize what's truly Trumpian and outrageous about his conduct, that after taking them away, he engages really in a 2-year campaign, but the last several months completely lawless, disobeying subpoenas, lying, etc., thinking these are my documents and they can't take them back. That whole aspect is essentially indefensible. That's where even Bill Barr has said Trump, has no leg to stand on. False statement. So we'll see what that is, but there have been some kind of lies made to law enforcement people. It might not necessarily be by Trump, because we also have a conspiracy count under 18 U.S.C. 371. It takes more than one to conspire. It doesn't have to be named, but I suspect that it will be named, and that will be very important. And a little bit of a surprise, a count under 1512, which essentially is witness tampering. So I think my best hypothesis there is Walt Nauta, his, trusty valet, Diet Coke gopher, and, general hoverer and yes man, told the FBI that there were no sensitive documents there, everything's fine, when they first talked. That's an outright lie and a violation of 1001. It's not perjury because it's not under oath, but it's still a violation. And then he fessed up on the second go round. So I think 1512, it may well be that Trump pushed on Nauta to lie to the FBI. And it might well suggest, it does suggest that the way they're going to prove that is that Nauta, the loyal valet gopher, has turned on Trump and is going to give truthful testimony, because otherwise he's so much in the soup. All right, so those are the charges. Now, again, we've been paying close attention as In the last week, as it became clear that there was a lot going on in the Southern District of Florida and in D.C., by contrast, the grand jury hadn't met since May 5th. So what was that about? And it's now clear they were bringing the case down there. They had decided that they wanted to avoid any venue battle. And I've talked about this before, but venue, though it sounds kind of a procedural thing, is actually guaranteed by the Constitution. It's part of sort of a jury of your peers. You should be tried, says the Sixth Amendment to the Constitution, in the district where the crime was committed. And the law's a little bit in flux. In fact, the Supreme Court has just heard a case on it, but there's at least a strong possibility that if you take a defendant to trial in the wrong venue, get a conviction, and then it's overturned for venue purposes, you may not retry that defendant. So it would be a complete loss of the case. So they, I think, really wanted to be careful about venue, and that's why they've packaged it in the Southern District of Florida. Obvious downsides there. They could get worse judges. The famous Eileen Cannon, who totally was in the tank for Trump at the beginning of the special master process, you'll recall, she's in the Southern District of Florida, and others. Whereas in D.C. are some very sophisticated, solid judges who know in particular how to deal with classified documents, as this case will include. So that's one. Second is the jury. The jury pool down in Florida, it's got to include a lot more rabid Trump supporters. There's basically none in the District of Columbia. And if they wear too much on their sleeve, they'll be dismissed. But there'll be a possibility that a MAGA person sneaks through and is on the jury. Now, that's happened a couple times. We've had MAGA folks on juries, and they've done the right thing. They followed the evidence. And even here, should that happen, the worst possibility would be a mistrial. You're not going to have 12 jurors disregard all the evidence. And at this point, the U.S. is all in. Trump, of course, would crow if it were a mistrial, but they would retry him and, be more until basically there's a conviction. Now, it won't be the case, as some have speculated, that he'll be a convict by the time of the November 2024 election, where he's still considered the very big front runner. And we'll see if the next few weeks erode that presumption at all. But he would have appeal rights. And until an appeal is final, he wouldn't be a convict, a felon. So it's still certain that come November 2024, he's going to be at liberty, I think. Very unlikely that a judge could put him in jail pending an appeal, but very unlikely that I think he would. There'll be somewhat, weighty issues no matter what to try to go through. So there you have it. At the end of the day, it's in the Southern District of Florida. Everything that seemed to be happening from the target letter and before was happening. And he essentially was being treated, since Smith came on the scene, and will continue to be, like any other defendant. That means if he's convicted, I think DOJ has to push for serious jail time. A judge wouldn't have to allow it, but that, we'll see what happens there. There is a little bit of a test now of the courts and the society, how it will handle this, if we'll have a regular and respectful process, and people not be rioting and judges be up to the task and the like. Other things that I'll be looking for avidly is the 1512 involve Walton Alta, and what about Mark Meadows, who seems like as if he may have been cooperating, and recent reports show may have taken away 1,000 classified documents just before leaving the White House. Those are big details that we'll know by Tuesday, if not before, but enough for one day. The biggest indictment in the history of the United States, and a really ringing triumph for the rule of law. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.